evidence. So the court has found probable cause. We now have to move on to the issue of detention. And I'll hear from the state.
Thank you, Judge. This defendant scores a 4 for risk of failure to appear and a 5 for risk of new criminal activity on the PSA, as well as an elevated risk of violence flag. The recommendation is no release due to the NVCA flag and the current violent charge. There are no failures to appear in the past 2 years, but there is one older than 2 years from 2005. Given the gravity of the charges that defendant is currently facing, including a second-degree charge for robbery and a second-degree charge for aggravated assault, this also suggests that the failure to appear is more likely, especially since both of the second-degree charges are listed as near charges in the PSA. Factor 2 is whether the eligible defendant will pose a danger to any other person or the community. This defendant has 3 prior indictable convictions for possession of CDS, as well as abuse, abandonment, cruelty, and neglect of a child, and theft. She also has 3 prior disorderly persons convictions for shoplifting, wandering or prowling to obtain CDS, and a contempt of a domestic violence restraining order. Furthermore, there is a pending charge for a simple assault that occurred back in October. The PSA indicates that this simple assault is also domestic violence related. There is an active final restraining order against the defendant that has been in place since 2023, which is further evidence that she poses a danger to the community if released. Next, I'd like to turn to the events of the current case where defendant hit the victim with a vodka bottle, aggravating an injury the victim sustained also from defendant when the defendant pushed her into a metal handle in the shower. Not only did the victim complain of pain, but it was also confirmed through x-rays that her 5th rib was fractured. Defendant also actively attempted to prevent the victim from calling for help. Furthermore, this conduct occurred while defendant was on parole. Despite being on parole, she has incurred new criminal charges for domestic violence-related offenses. The state is not confident that any imposed pretrial release conditions will be sufficient to ensure the safety of the victim. The victim reported to the responding officers that defendant is her girlfriend, given their dating relationship, and the fact that they were found in the same residence. The state would argue that the likelihood of the defendant returning to that location is very high, and as such, the state is extremely concerned about the safety of the victim in this case. Factor 3, whether the eligible defendant will obstruct or attempt to obstruct justice or threaten, injure, or intimidate, or attempt to threaten, injure, or intimidate a prospective witness or juror. Defendant does have a conviction for contempt of a domestic violence restraining order just 2 years ago in 2023. I'd also like to reiterate the fact that the defendant attempted to pull the phone away from the victim in this matter when she tried to call for help. Even the responding officers noted in the affidavit of probable cause that they could hear someone screaming, "Give me back my phone," when they arrived on scene. This is clear evidence of defendant's attempts to obstruct the criminal justice process and prevent the victim from seeking help in this case. The state is not convinced that any monetary, non-monetary conditions or a combination of the two would meet the interests of the triad. And for the aforementioned reasons and for the safety of this victim in this matter specifically, the state respectfully requests that the motion to detain defendant be denied. Thank you.
Okay, Ms. Bitters, I'll hear from you, but I do have a question, and either one of you can answer it. I did see that the defendant was currently on parole. I didn't understand how that happened. I looked at her prior indictable convictions. She had 3. The closest one in time to this was a January 11th, 2019 possession charge. I obviously don't have a criminal history where somebody could tell me what she was sentenced to in that, but 2019, and we're in 2025. Is she on parole? Was she on parole at the time this happened?
Judge, she may be able to better answer that, but my understanding is that she was in recovery court and she was sentenced to her alternative sentence. Maybe that's what she's on parole for, but she's raising her hand. She might be able to.
Can we unmute the defendant, please? Ms. Greer, were you on parole when this happened?
No,
Are you
sir.
on parole now?
No, sir, I'm not on parole. I'm not on probation. I'm not on anything. I haven't been in trouble in over 4 years. And one thing I want to say, is there anything in there where Danielle strangled me? I have one video with the cops. She had me strangled and they asked me if I wanted to press charges and I had said no. Is there anything about that? Because I really was not violent towards her. I was trying to de-escalate the situation from her calling the cops. I did not try to take the phone from her. I never hit her with a vodka bottle. She woke up in the middle of the night at 2 o'clock in the morning, drunk, I was sober. I went to pour the alcohol down the drain because I didn't want to fight no more. And I understand. I don't want to see her. She's practically ruined my life. My sister Nicole Gollum, Weidenkrantz, works for the county. She's now a 911 dispatcher. She's willing to let me stay out of her house. I'm willing to go on the bracelet, report every day, do drug tests, anything that you need me to do. I need to be able to salvage my life. And I can't do that by being in here. I don't want to have no problems with her. I don't want to have any contact with her. I actually want to counteract the restraining order and put one against her. I don't want to have any more issues. And I want to have an opportunity to protect myself. And I can't protect myself by being behind bars. My sister is a very big advocate. Miss Holly Bitters will tell you, she was my public defender when I was on drug court. She knows how supportive my sister is. During COVID, they even let me out to my sister's house for my sister to drive me to my rehab. That's how much they trusted within my sister. That's how much they trusted in me. I'm really not a violent person. Yes, I know on paper it may look like that, but something on paper doesn't judge a person for who they are.
Excuse me, Judge. Judge
Right.
Wall been sentenced to 3 years in state prison, August 16th of 2021. So that was the
3 years.
Ms. Bitters
August
was
of
correct.
21.
Yes, Judge.
Yeah.
So she shouldn't be on
Okay.
parole.
I'm not on
She
parole.
is or not?
She should not be on parole, Judge.
That's what I didn't think so. I had a question mark on that. Okay. Ms. Bitters, I apologize. Would you like to add anything further with respect to detention?
Judge, we'll just note that Ms. Geyer is 40 years old. She's not on probation, parole, or pretrial monitoring. She is a college graduate. She has a very supportive, like she said, very supportive local family who she's close with. She has an alternative address that she's able to live at with her sister. It's our position that for the reasons we talked about when arguing for probable cause, that the state's case here is pretty weak despite the serious charges. I would hope that, this case resolves for something quite less than what she's charged for. It certainly doesn't seem like a second-degree robbery or a second-degree assault. As Ms. Geyer stated, this was a mutual fight. Ms. Geyer was actually probably the most injured. Police reports note that she had visible injuries on her neck, and I believe Ms. Geyer also had broken ribs as well. She does have a very limited prior record. She has 3 prior indictable convictions. Like the court noted, the most recent was pretty old. I think it was 7 years ago. She only has 1 failure to appear to court ever, and that was over 20 years ago. So I think it's clear that she's not a flight risk. She's not a danger to the public. She has no really serious violence on her record other than these pending charges, which hopefully won't stay as what they are. She's not a danger to this particular victim. There are conditions that could be set that would assure that alleged victim's safety. Ms. Geyer will abide by any conditions that are set by this court. She's not a risk to obstruct the process, and for all those reasons, we believe the state has failed to meet their burden here for detention.
All right. The state has moved for pretrial detention, and after conducting the hearing, the court did find the state had established probable cause that the eligible defendant committed the charge based upon the affidavit of probable cause that we had marked in as S1 that was actually read by the state. There was some other evidence that was relied upon, which was the visible signs of injury and the x-ray that established a fracture of the 5th rib. Obviously, the defendant has not been indicted yet for these offenses. The court I don't think I have a lot of concern, and I don't think that the state has established by clear and convincing evidence that this defendant would not appear in court. So I don't find that the state's established that portion of the triad. I'm not sure that the state has established that she would be a danger to the community, or that there wouldn't be any conditions or combinations that would lower the risk of danger to the community. So I'm not sure that aspect of that triad would be there. However, with that said, I do believe that the state has proven by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or combination of monetary bail and conditions would reasonably assure the protection of the safety of another person. And in that situation, I think it's the victim in this case. I don't know how I could order this defendant to have no contact with her when she had one incident where apparently there was fractured ribs, and then subsequently we had an elevation of that. But of more concern is that this defendant has a prior conviction for contempt for violating a domestic violence restraining order. So if I were to order that she have no contact with this victim, I would not have clear and convincing evidence that this defendant would abide by that order. The evidence is to the contrary, that she had a restraining order and a no contact provision in a domestic violence situation and ignored the court order and was convicted of that. So I do believe that in terms of the triad for the protection of the safety of other persons, that the state has proven by clear and convincing evidence that no combination condition of monetary bail would assure that. I also find that the state has proven by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or combination of monetary bail and conditions could reasonably assure that the defendant would not obstruct or attempt to obstruct the criminal justice process. Again, this is a domestic violence situation. The victim in this case clearly had a relationship with Miss Greer that she attempted, and I think aptly pointed out by the state, that when she wanted to call the police, it was Miss Greer that took the phone, preventing her from calling the police, clearly obstructing the process by those actions. Furthermore, as I've indicated, she has a criminal conviction for a violation of a domestic violence restraining order. Clear and convincing evidence that this defendant would attempt to obstruct the criminal justice process. I'm going to therefore find pretrial detention of the defendant is hereby ordered. The nature and circumstances of the offense charged. I realize it's a low bar, but we have a second-degree robbery charge, a second-degree aggravated assault, and a domestic violence simple assault. And the other aggravated assault is also domestically tied. The weight of the evidence against the defendant, considering the admissibility of any evidence sought to be excluded. We have personal observations of the law enforcement officers that evidenced redness to the rib area of the victim, Danielle Maryless. We have an x-ray. We have a statement of the witnesses. I didn't see where there was body camera footage on this, but normally there would be body camera footage which would provide the statement of the defendant in this matter. The history and characteristics of the defendant, including defendant's character, physical and mental condition, family ties. She has got strong family ties to the community. I accept that. Accept the fact that she may be able to have and is employed. She's a lifelong resident, I believe, of the Atlantic County area. She's got community ties. She does have a history related to drug or alcohol abuse that was not curtailed by even drug court, or sorry, recovery court. I apologize, recovery court, because she failed and ended up getting her alternative sentence. I have reviewed the criminal history as reflected in the PSA. But I don't think that as defense counsel has aptly pointed out, that those would cause the court great concern. What is of greater concern, as I've indicated, is the fact that this is a domestic violence situation where that's escalated over a shorter period of time, and that I've got a violation of a domestic violence restraining order conviction. That's the greatest concern that the state has in terms of the safety of that victim and the defendant's attempts or potential attempt to tamper with that victim's testimony. And I don't think I could order her to not have contact with her and have any type of clear and convincing evidence that she would abide by that, despite what she's indicated to the court today, because she has a conviction. When a judge ordered her and there was a restraining order in effect, the defendant violated that. I note that the PSA indicates that she was on parole. I don't believe that that's accurate. I had trouble when I looked at the PSA and the dates of her convictions. It does make sense to me that in 2021 she would have violated and been sentenced, but I think on a 3 she would have been off parole at this point in time. So I'm not sure that that's accurate in that terms, but I do give great weight in terms of the public safety assessment, not necessarily to her failure to appear, but with respect to the new criminal activity as a 5, and that this was a NVCA flag and current violent charge, so no release was recommended. I do find, as I've indicated, that there's potential for witness intimidation and obstruction of evidence because of the nature of these charges. The PSA has a recommendation for not release. For all of those reasons, the court finds that the state has met its burden by clear and convincing evidence. There are no conditions, whether they be monetary or non-monetary or a combination of both, that would reasonably assure the protection of the safety of another person, and that's the victim in this case, and that the defendant would not obstruct or attempt to obstruct the criminal justice process. The defendant should be provided an opportunity for counsel, and I'm advising you have 7 days to appeal the court's decision. Thank you, everyone.
Judge, the defendant raised her hand. Did you want me to unmute her or not?
Ms. Bitters, you want her to address the court at this point?
Judge, I would just advise Ms. Guyer that Desiree, the judge has made his decision, so anything you say is not going to help you at this point, and everything you say is being recorded. So I don't want you to say anything because everything can be used against you. She still looks like she's talking.
So,
All right,
Judge,
can we unmute her?
yes, Judge. She's unmuted, Judge.
Sir,
Ms.
you
Greer, I
keep
want you to
saying,
understand that I've ruled, ma'am. So
yeah, no, I understand that you ruled and I understand what your decision is. I'm not fighting with you about that. But you keep bringing up that I had a restraining order that I violated, but also that restraining order was dropped.
I understand that, but you have a
was
conviction,
dismissed.
ma'am. You have I appreciate you didn't have a restraining order at the time this happened. The concern that I had, and it's a big concern, is that there was an order issued by a judge that prohibited you from having contact with that domestic violence victim, and you violated that, and you were convicted of that. It was a disorderly person offense conviction. So even though there's not one now, when a judge issued an order, you ignored it. And that's the biggest concern I had, ma'am. All right. Thank you, everybody.
Ma'am, you can leave the booth. Ma'am, you can leave the booth. Judge, the next.